On this week's episode of the Crushing Debt Podcast, why so many documents?
Welcome to the Crushing Debt Podcast with your host, Florida attorney Sean Yesner, where our goal is to help you get rid of the financial bullies in your life.
So welcome back to this week's episode of the Crushing Debt Podcast. My name is Sean Yesner, owner and founder of Yesner Law. And so I had a question come up recently with a client, and I wanted to answer it on this week's episode. Before I get into the particulars, though, of the episode, I did again want to talk about our friend, our sponsor, our referral partner, Sam Cohen with Attorneys First Insurance. Those of you that have been longtime listeners know that I'm always giving Sam a plug on this show. He is our sponsor, and so I want to do what I can to support him back for that financial contribution he makes to the show. And so what I'd love to do is introduce him to attorneys and title companies that need malpractice insurance. That's what Sam Cohen and Attorneys First Insurance do. They write errors and omissions insurance or E&O insurance or professional liability insurance for attorneys and title companies all over the state. Now, Sam is focusing on Texas and Florida right now. He's here based in Florida with me, and he's focused on Texas and Florida right now, but can write insurance for attorneys almost anywhere in the country. And so if you want to support the show, if you want to support our sponsor, a great way to do that would be to introduce Sam to attorneys and title companies whose malpractice insurance is coming up for renewal. He is not a hard sell, and if he can't make their insurance better, he won't write it. If what they have is good enough, he will tell them that. If he can improve on it, he will tell the attorney or title company that as well. So a great way to make the introduction would be sam@attorneysfirst.com or www.attorneysfirst.com. The other thing that I want to talk about, and I mentioned this in last week's episode, and I'm going to mention it for the next couple of weeks, although if you're listening to this podcast after November, you're going to have to catch it in 2022. But Podfest is coming back to Tampa live. Now, Podfest is a conference specifically designed for content creators, episodic creators, podcasters, YouTubers, Facebook Live, Instagram Live, or Instagram TV, TikTok, all that kind of stuff. And it's designed to help those of you that want to have a show, already have a show, want to be a guest on a show, want to have guests on your show, want to monetize your show. That's what Podfest is designed for. It started here in Tampa, 7-8 years ago, I think, is when it started here in Tampa. The first couple of years it was in Tampa, and then it grew so big it got moved to Orlando, where it spent the next 4, 5, 6 years. We were actually one of the last conferences in Orlando to go start to finish before COVID shut everything down in March of 2020. Podfest then went virtual in 2020 and earlier this year, 2021. But now we are going back to live. And so the live is going to be November 4 and 5 at Amalie Arena. Those of you that don't know Amalie Arena, that's where the world champion Tampa Bay Lightning hockey team plays. The 2-time back-to-back champion, 3-time overall champion Tampa Bay Lightning play at Amalie Arena. So it's going to be a really cool venue for Podfest. I understand that the Bitcoin and blockchain conference is also going to go on there simultaneously. And so if you're interested in podcasting, if you're interested in blockchain or Bitcoin, definitely podfestexpo.com is where you can find out some more information. I'll be there speaking on the Thursday of the live, November 4, I believe, at 3 o'clock p.m. And so if you're at Podfest Live, go ahead and say hello. Find me. I'll be there all day on the 4th and the 5th. So find me and say hello, and let's chat and let's network. But what I wanted to talk about this week, turning to today's content, why so many documents? So as you know, I file a lot of bankruptcies for people, and I'm very, very often asked, why so many documents? Why do I need so many documents in order to file for a bankruptcy? Now, one of the issues there in the background is that there is something called a bare bones petition. Now, a full-blown bankruptcy petition, you're probably looking at somewhere in the range of 50 pages, 45 pages, 50 pages, 60 pages, something in that range. But the petition itself is really only the first 7 or 8 pages. And so when someone's in a hurry to file, they do what's called a bare bones filing. They'll file just the first 7 or 8 pages of the petition, and then they'll follow it up with the rest of the schedules. And I've talked about bare bones petitions before. You can look it up in previous episodes of the podcast. Those of you that are longtime listeners know I don't like doing bare bones petitions for a couple of reasons. Number one, it increases the cost, because when we follow up later and file all the schedules of all the debts, I have to pay an additional fee to file that debt schedule, because that debt schedule needs to be sent out to all the creditors. And so if I file it at the time the petition is filed, it's fine. If I file it afterwards, I got to pay an additional fee. It's also a lot more work, because not only do I have to create the initial petition itself and do a lot of the due diligence that I would have to do anyway, I then have to follow it up with all the due diligence to complete the schedules. So it taxes the staff a lot more. It takes a lot more time, effort, energy, money. So I really don't like doing bare bones petitions. Have I in the past? I'm sure I have. But I really, really don't like doing them, and I try to avoid them if I can. And that's why when a lot of times someone called me yesterday and said, I need to file a bankruptcy petition today. Well, I'm sorry. While it is physically possible, while it is technically possible to get a bankruptcy up and running in a day, I really don't like doing it, because that's when I rush and miss stuff and make mistakes and create additional work and time and effort and energy, bare bones petitions, all that kind of stuff. So I really don't like doing it in a day. Can I if I have to? Probably. But I really don't like doing it. I prefer to have at least a couple of weeks. So if you want me to help you with your bankruptcy, at least give me a couple of weeks at a minimum. So what is it that I need? And that's really the topic of today's episode. You know, I send a checklist out to every client and say, here's all the documents I need to get your bankruptcy filed. And a lot of times they say, well, why so many documents? And so what I thought I'd do is go through my due diligence checklist. Now, this is not the end-all be-all of everything that you need to file bankruptcy, especially if you're outside the state of Florida. Work with your bankruptcy attorney, get your bankruptcy attorney whatever documents he or she asks for. These are the minimums that I ask for. I may ask for additional stuff after I review all the stuff I'm about to go over. So this is not the end-all be-all. This is not all-encompassing, and this is not the final checklist of documents that I would see in every case. But this is at least the bare minimum. And so in no particular order, and I'll explain what it is that I want to see and then why I want to see it. So the first thing, I need 6 months of pay stubs. Now, a lot of people say, well, I work for myself, or I don't have pay stubs, or I get paid on a 1099 basis. Whatever it is that you would give your CPA to prepare your tax return, I need the last 6 months of that. So obviously, if you get pay stubs, that would be the best thing. If you're self-employed and you use QuickBooks or some kind of accounting program, the last 6 months. And I need it broken up by month. So don't just send me January through May, or January through June. I need it broken out by month. So how did you do in January, February, March, April, May, June? How did you do in those months individually? Again, whatever it is that you would give to your CPA so your CPA can prepare your tax returns, I need the last 6 months of that. Now, if you get paid, if you're a W-2 employee, or even if you're a 1099 employee that gets paid, monthly or every 2 weeks or whatever, the last 6 months of whatever it is that shows what and how and when you got paid and how much you got paid. That's number one on the list. And again, that's for purposes of preparing the means test. That's for purposes of preparing your budget. So there's a lot that goes into the pay stubs, or pay advices, I think is the bankruptcy code calls them, within the last 6 months. The other thing that I'm going to need, 3 months of bank statements for every bank account that you have, whether it's business, whether it's personal. 3 months of every bank account that you have. Now, I don't care if there's been no activity in that account for 6 months. I still need the last 3 months showing there's been no activity. I don't care if there's $5 in that account. I need every statement for the last 3 months that shows that there's been no activity and there's only $5 in that account. I need the last 3 months of every bank statement, and that's for a couple of different reasons. Number one, it's an asset, and so it is something that we have to report as an asset, the money you have in the bank. Number two, it goes a long way towards showing the trustee, what have you been doing? Have you been moving money around I don't want to say improperly, but have you been moving money around in such a way that it may not escape being an asset of the bankruptcy estate? How are you getting paid? Do your pay stubs match your bank statements? Are you getting paid by family? Are you paying family? All those different types of issues can be determined by looking at your last 3 months of bank statements. So we need those. I need your last 2 years of tax returns. And a lot of that is because, number one, your tax returns need to be current in order to file your bankruptcy, in order to get your discharge. So we need to know that they've been filed. Number two, that'll also show the IRS that they've been filed. And so if the IRS says, no, we don't have proof that these returns were filed, at least we've got the last 2 years, we could file them at that point. It's also going to tell the trustee a little bit about what we're reporting in the bankruptcy petition. I mean, if you've made $50,000 a year for the last 2, 3, 4 years, and this year you say you've made $20,000, well, what caused that $30,000 decrease in your pay? Same thing. If you've made $50,000 a year for the last 2, 3, 4, 5 years, and now you're making 80, what happened to give you that additional 30 grand in revenue? Was it an IRA distribution? Was it the sale of a house, of an investment property, whatever? What is it that, is your income this year consistent with the last couple of years? Plus, they need to be filed. Now, if you have a business that you own, I also need your corporate tax returns for at least the last 2 years. And again, the same analysis. Is this a business that crashed? Is this a business that maybe hit a vein and made a ton of money? So we need your tax returns to identify that information. You also need to do your credit counseling. So again, before someone can file bankruptcy, they need to do credit counseling. It takes about an hour. There are certain providers that will give you that information. They prepare a certificate. I need that certificate before we file. So you need to do your credit counseling. And again, I can give you information on the different providers and how to do that and when to do that. It needs to be completed before we file, and it's good for 180 days, which is about 6 months. Now, that may change if, February's in there. There are a lot of months in there with 30 days, but the rule is 180 days. But basically, it's good for about 6 months. But we need your credit counseling certificate in order to file bankruptcy. We also need a copy of your driver's license or your ID, whether that be a passport, government-issued ID. We need to know that you are who you say you are, especially in this age of COVID, where a lot of trustees are doing meetings and hearings and courts are doing hearings by telephone. We need some confirmation that you are who you say you are, more than you coming into the office and me meeting you and saying hello. We need your driver's license or other government-issued ID, whether that be a government-issued non-driver's license or a passport or something. We need something to identify that you are who you say you are. Along those same lines, we need your Social Security card. Now, if you don't have your Social Security card, we need something that you did not prepare that has your Social Security number on it. So a statement from the Social Security Administration, or maybe a W-2 or a 1099. We need something that was prepared by somebody else that has your Social Security number on it. And why is that? Well, 2 reasons. Number one, we have to disclose to the bankruptcy court whether you filed bankruptcy before. Now, I have access to a program that can do a nationwide search based on Social Security number to see if that Social Security number has ever filed bankruptcy before. So that's one reason we need your Social Security number. The other reason is because bankruptcy is based on Social Security number, if we get your Social Security number wrong, we're filing for someone else. And so do all the Social Security numbers line up? Is the Social Security number that you provide us the same one as on your W-2, the same one as on your 1099, the same one as on your tax returns, the same one as on your bankruptcy petition? They all have to line up, and we have to verify all of that. So we need your driver's license, and we need your Social Security card or Social Security number in order to get your bankruptcy filed. We need a retainer agreement. Now, I send out a retainer agreement for, I would think, pretty much every bankruptcy we file. If I didn't send one out, it was probably a mistake or an oversight on my part. But I try to get a retainer letter out. I'm pretty good at getting a retainer letter out for every bankruptcy that we file. And if for some reason I don't do it beforehand, I'll do it on the day you file your bankruptcy petition. Now, why is that? Number one, that's the contract between you and me. So it's going to say what it is that we're doing for you. The other reason is the U.S. trustee and the bankruptcy trustee have the ability to question our fees, make sure that our fees are reasonable, as does the court. And so having that retainer letter goes a long way to proving to the bankruptcy court and trustee and U.S. trustee that our fees are reasonable and we're charging what we say we're charging, and we're reporting to the bankruptcy court what we're reporting to the bankruptcy court. And again, everything lines up. So it's a piece of due diligence. But unfortunately, we do need you to sign that retainer agreement. Now, I'm not going to get all fancy about it. I'd like to get an original signature on it, but if it's e-signed, if it's signed and scanned back, it is the contract between you and I. It is rare that the trustee or court or U.S. trustee asks to see it, but it's still something I need to have in my file. I know the U.S. trustee would prefer the, quote, wet signature, the blue ink signature, so to speak. But it is, again, one of the documents that's part of our due diligence that's required in order to file a bankruptcy case. I need to know what type of life insurance policies you have, especially if they are cash surrender value life insurance policies, whole life insurance policies, investment life insurance policies. Then I need all the documents and statements and whatnot to show what type of life insurance policy it is. Similarly, IRA statements, retirement statements, that kind of stuff too. We need to disclose, even though all that stuff is exempt under Florida law, it's still something we need to disclose to the bankruptcy court. I need to get any leases and rental agreements that you have. Any leases and rental agreements that you have. Now, I don't care if it's a self-storage rental, a home rental, whether you're the landlord or the tenant, whether it's a car lease, whether it's whatever. Any contracts that you have with third parties where you've agreed to pay, I need copies of those leases, those contracts, those documents. And again, it's a function of what debt do you have, what assets do you have, and so all of that is the backup and support for that type of information. So any lease agreements, rental agreements, contracts, anything you have that would show what assets you might own, what expenses you might pay, all that kind of stuff. I need all of that. I need your mortgage statement, I need your mortgage payoff, and I need your house value. Now, again, I think those should be obvious. I need your mortgage statement to see if you're current or behind or what your monthly mortgage payment is. I need your payoff to see how much you owe the mortgage company. And obviously, I need the value to see if there's equity there. I need the same thing for cars. So car statement, what's your monthly car payment? What's the payoff? If you were to pay off that car, how much would it cost you to pay off that car? And then again, what's the car's value? KBB, Blue Book, whatever Edmunds, whatever valuation, CarMax, whatever valuation you can get on the car, because I need to know, is there equity in the car? How much do you owe to pay it off? What's the car worth? What's your monthly payment so we can include that in your budget? Do you have equity that we need to include as an asset? All those questions. So mortgage statements, mortgage payoff statements, house value statements, car payment statements, car payoff statements, and car values. I need all of that stuff. And again, if there's other secured assets like rooms to go, I would need the same type of information in terms of a living room set that you bought or a dining room set that you bought, any secured asset, a HVAC system that you bought, water softener system that you bought, the same information. What's it worth? What do you owe on it? What's its value? And is there any equity in it? I need all of that stuff. I need any statements you've received from collection agencies, unsecured creditors, medical bills, Visa bills. Now, we are going to run your credit report. That is part of the fee that you pay to me, is that we're also going to run your credit report. But I like to have those statements, number one, to verify that the credit report is accurate, that maybe one of these companies has not reported to credit, and so we still are able to capture all of your creditors. I also need to know any addresses, and so the statements will have that, correspondence addresses, and so the statements will have that. How much you owe, the statements will have that. Sometimes the credit report runs 2 to 3 months behind, and so what it says you owe on your credit report may be different than what the statement that came out a few days ago says that you owe. So I need all of that information as well. Any credit card statements, any letters from debt collectors, any of that kind of stuff. I need to see what you owe. A couple other things here. I need your tax bills. So if you own property, I need to see the real estate tax bills for the last couple of years. Number one, just to make sure that they were paid. If not, they become a secured debt against the property. Number two, it'll give me insight into any and all properties that you own, whether it's just the one homestead, whether it's none, whether you have an inventory of investment houses. Having the tax bills will show what and who and how much you owe on these houses above and beyond any mortgage payments. The last thing that I typically include as part of my due diligence file is my consult notes. In other words, I'm going to ask you a lot of questions in the consult and try to find red flags and try to issue spot and try to do any of that stuff. Now, I have to be an open book to the bankruptcy court, and I suggest to my clients that you be an open book to the bankruptcy court. Don't try to hide anything. Don't try to do anything like that. And so part of the reason I want to compare my consult notes to the bankruptcy petition, are there any red flags that I spotted in the initial consultation that you didn't tell me about when we were creating the bankruptcy petition? My memory is not perfect, and that's why I write down consult notes. Is there anything you disclosed, like someone passed away and you're due an inheritance, but then when it comes time to create the bankruptcy petition, you leave out that inheritance because you want that money? That's one of the things. Do you have expensive jewelry that you leave out of the bankruptcy petition? Now, again, I'm not suggesting that any or all of my clients are maliciously doing this stuff. I mean, people are genuinely nervous about losing the inheritance, losing the jewelry, losing the tax refund, losing assets, not being able to provide and pay for their family. So I totally and completely get why someone would be scared. And I don't think that anybody excludes anything from a perspective of malice. Now, that may be me being too optimistic about my clients. But again, that's what the consult notes are for. Did you disclose? And again, anything you say to me is confidential. If you, whether you hire me or not. So if you tell me, hey, listen, I'm getting an inheritance of $1 million, and I write that down in my consult notes, and then we get to the bankruptcy petition, and I say, hey, you mentioned in the consult that you were getting $1 million inheritance, and you say, well, I don't want to disclose it because I don't want the bankruptcy trustee to get it, and under attorney-client privilege, I am prohibiting you from disclosing it. There's a couple of layers there. I mean, first of all, I'm not allowed to assist or help you or allow you to perpetrate a fraud. So that may be one of those situations where I could break attorney-client privilege. But probably what I would do is say, I'm sorry, if you're getting $1 million inheritance and you are refusing to allow me to disclose it, then I think our representation, our relationship needs to end, and you need to find a new bankruptcy attorney. Because if the bankruptcy trustee or the United States trustee or the court catches you or me in a lie, the FBI comes knocking on the door. And as much as I love you, and as much as I love my clients, and as much as I really want to help everybody, I do not want to do it at the expense of my license. And so I cannot disclose anything that you prohibit me from disclosing unless there's a fraud or you're going to commit a crime or something like that. But at the same time, if I feel it's necessary to disclose something and you refuse to allow me to do so, I may have no other choice but to end the representation to prevent me and my firm from having any negative consequences to your dishonesty. Whether it's malicious or not is really irrelevant. I just can't assist in something like that. So that's the reason I want to see the consult notes. So again, is this a comprehensive list? Absolutely not. There may be more things that I want to see based on some of the answers to some of these questions. For example, if you own a business, I may do a search with the Florida Secretary of State to see how many businesses you own, what the status is of those businesses. Are they operating? Are they up to date with their fees to the Secretary of State? So there may be other things that I want to take a look at based on what you tell me in our consultation and in the petition itself. But this is a very basic minimum list of the documents that build my due diligence file. So again, that's why we need a lot of this stuff, is we need to make sure that we're being accurate and honest. I mean, keep in mind, when this bankruptcy is successful, your debt will be gone, either 100% or at some percentage, or it'll be gone based on a controlled payment plan. So you get a huge benefit here by filing bankruptcy. And I get it that it's embarrassing. But, bad stuff happens to good people, and everybody's entitled to a second bite at the apple. That's what bankruptcy is for. But I need this due diligence to protect you as much as protect me, and make sure that at the end of the bankruptcy, everybody is discharged. Everybody that we can discharge is discharged. Everybody that can be eliminated is eliminated. So that'll do it for this week's episode of the Crushing Debt Podcast. I very much appreciate your listening and doing the due diligence in this way, and getting the bankruptcy discharged properly will definitely help you have more money at the end of the month than more month at the end of the money. Thank you again for your time and your listening. Make sure to check out Sam Cohen at attorneysfirst.com. Make sure to check out podfestexpo.com for the virtual pre-week and the live event on November 4 and 5. Come check me out if you come down for Podfest in Tampa at the beginning of November. If you're listening to this episode at the end of November, definitely check back. I'm sure there will be another Podfest live. I'm sure there will be another Podfest virtual. So check back to this show. Check back to podfestexpo.com to get more information about that. That'll do it for this week's episode of the Crushing Debt Podcast, and we look forward to talking to you in next week's episode.
If you have questions that you think would make a great topic for a future episode, please email Sean or connect with us on social media. Sean Yesner and Yesner Law, PL, are Florida licensed attorneys. The information contained in this week's episode is not a substitute for legal advice. Your situation may differ, especially if you are located somewhere other than the state of Florida. If you have questions, please contact our office or contact a local attorney. Thank you for listening to this week's episode of the Crushing Debt Podcast.